Sometimes it's said that the bankruptcy code is filled with landmines, and to a certain extent that's true, and I want to go over one of those landmines, which deals with the IRA exemption. The general rule of thumb is that IRAs are exempt, and almost anything you read will say, well, don't worry about your IRA because it's exempt from the claims of creditors in bankruptcy. If you read the code, though, what the code says is that if an IRA has received an IRS determination letter, then there is a presumption that it is exempt. And every lawyer knows there's a lot of danger in that word presumption, because it immediately tells you that there's some ways that it might not be exempt. And a good example of that is in a recent case involving a Merrill Lynch IRA, and approximately $400,000 or $500,000 in this IRA. And the bankruptcy trustee in that particular case went into the boilerplate language that Merrill Lynch has a customer sign when they open an IRA, and they found in it language to the extent that if that customer were to owe Merrill Lynch money on any other brokerage account, for instance, if there was a margin call on a brokerage account that they had in their individual name, that Merrill Lynch could cover that debt by taking money out of the IRA. The trustee successfully argued that that was a prohibited transaction, and therefore the IRA should not be exempt. And they won. And they took it to the appellate court, and they won again. So a caution to everyone who has an IRA is to go in and find out if the brokerage firm or the sponsor of the IRA has any type of lien rights on the account. And if they do, you need to move that IRA immediately.